Hi, everyone. Welcome. I know a number of people were in the waiting room. And because we have a ton of content to get into, have a really great conversation tonight. I'll just let you know that we will be taking questions, but if you don't mind sending them into the chat, and we'll look at them at the end. Hopefully some of your questions would be answered throughout. So to get completely started, I would like to welcome everyone on behalf of the Law Commission of Ontario. This session today is going to discuss reforms to the Ontario justice system, looking to improve legal protections and services for survivors of intimate partner violence, or IPV. The topic is a long-standing and urgent access to justice issue in Ontario and across Canada. So this session is part of the Law Commission of Ontario's Improving Protection Orders project, and the LCO is Ontario's leading law reform agency. The project is looking to consider how to improve civil protection orders and other legal tools that could better prevent femicide and intimate partner violence in Ontario. So if anybody's interested in looking at more information on the LCO as well as the project, you could take a look on the website, which is lco-cdo.org. My name is Laura Ogden. I'm a 2L student at Laura Laskin Faculty of Law in Thunder Bay. And as well, I'm currently a student researcher with the Law Commission. So to get right into it, I'll introduce our panelists. So tonight we have Laura Snowden. Laura Snowden is also with the Law Commission of Ontario. She's working currently as lead counsel for the Improving Protection Orders project. Before that, she was with Gillian Natu and Co., which is a sexual assault civil litigation firm. She also recently completed work with the Commission Council, as Commission Counsel for the Mass Casualty Commission, which examined the circumstances of mass killings that took place in Nova Scotia in 2000. Moving right along, we have Deepa Mattu, who is the executive director at the Barbara Schleifer Commemorative Clinic. She's an award-winning lawyer with her roots in equity and anti-oppressive and anti-racist practice. She's also an adjunct professor at Osgoode Hall Law School. She sits on a number of boards and committees, including the Ontario Domestic Violence Death Review Committee. We also have with us tonight Dr. Frances Chapman. She is a law professor at the Laura Laskin Faculty of Law in Thunder Bay. Areas of interest for her are criminal law and focusing especially on defenses, including brainwashing, automatism, duress, necessity, and mental disorder. Particularly, she focuses on wrongful convictions, violence against women, and domestic violence. And then we have Neha Chugh. Neha, in 2014, started Chugh Law Professional Corporation in Cornwall. She has a love of the criminal law, working with individuals and families, seeking to serve vulnerable populations, working with community members, and she specifically focuses on youth and adult mental health litigation and research. So to get into not listening to me talking, I'm going to move over to our panelists, and I'd love to hear a little bit about the systemic issues that are currently at play, impacting individuals in the intimate partner violence realm. So Deepa, if I could ask you a little bit, the clinic itself was part of a collective effort in the recent advocacy to get Toronto to declare IPV an epidemic. Can you tell us a little bit about that process?
You need
Hi,
some out.
hi. Is the sound not working?
It doesn't seem to be. I also wasn't able to unmute myself to say that either. Um, oh, it looks like we might be good now.
Should be
Deepa,
good.
sorry, we couldn't hear you.
Oh, really? None of
I'm
that?
sorry. No,
I'm
sorry.
gold.
I couldn't tell you that we couldn't hear you either.
Okay, no worries. I have a second take on it. This, I apologize, everyone. So I started by saying thank you, Law Commission, for putting this together. I really apologize because I went into the role of answering the question without saying that you all were not able to see me. Or hear me, I should say. So the clinic, Barbara Schleifer Commemorative Clinic, I don't know how many of you know about it. Just very quickly, the clinic was started some 40 years ago in the name of Barbara Schleifer. And she was a young lawyer who unfortunately was assaulted and killed on the night of her call to the bar. Some of her friends came together to create the clinic, and clinic offers legal services, representation, and trauma-informed counseling and multilingual interpretation. Now, the city of Toronto earlier this summer declared gender-based violence as an epidemic. And just to give you a context, this term was first widely used by United Nations, WHO, and the General Secretary of the UN in 2013. Coming out of the pandemic, the clinic has witnessed a dramatic rise in the gender-based violence, with many clients across the city desperately seeking services. Just to give you a context again, the number of clients the clinic sees every year is around in the range of $14,000 to $16,000 people, which is almost 55% more clients that we were seeing, say, in 2020. So this declaration came right out of the recommendations of the Renfrew inquest. This recommendation was, the Renfrew inquest was really instrumental in providing the impetus for a lot of organizations to come together and ask the city of Toronto to declare the violence against women an epidemic. From my perspective, it's a first step. It's the step in the right direction, because I'm hopeful that it will inspire our policymakers and lawmakers and decision makers to spotlight the issue and take the necessary steps required to make gender-based violence a history. So the impetus came from Renfrew inquest, and I know that we'll hear a little bit more about it later during the panel today. Thank you.
Thank you so much, Deepa. Neha, could you speak maybe to the experiences of intersectionality for individuals that are kind of within the legal system?
Sure. So when I think about intersectional experiences, I think about not just cultural or ethnic divides. I think about, and not just male, female, I think about a lot of different factors. I think about economic factors. I think about the rural-urban divide. I think a lot about families of origin. I think about the communities that we come from and the places that we go. The thing that I hear the most from my clients, whether they are accused persons in the criminal justice system or they're survivors in the criminal justice system, what I hear the most is they're shocked by how long things take. They're shocked by the amount of time that it takes to get an answer, to get a no contact order lifted, or to have a final verdict in a case, or to have the opportunity to speak their truth in a courtroom, or to have a sentencing circle if that's what is their request. So what I hear the most is surprise, shock, upset over the amount of time that the criminal justice system takes, and that family courts take, for that matter. The other thing that I hear the most from my clients is the shock that of how siloed the system is. So the different levels of court are not speaking to one another. You don't have social workers speaking to lawyers. You don't have lawyers speaking to police officers. So everyone is kind of working in their silo. and trying to just get their task done, but not working in a collaborative or holistic approach to ensure that the person gets the most sustainable outcome. And so when I think about gender-based violence, when I think about intimate partner violence, I think about how can we ensure that this person is having both a trauma-informed approach, a sustainable approach, and something that's going to affect them for the long term. What that takes is both time and holistic approaches, something that I'm shocked as well to know that our justice system doesn't always provide.
Absolutely true. Being a student, the amount of steps that it takes to get anything to happen is astronomical. So over to Dr. Chapman. I know that some of your research has been specifically looking at the experiences of individuals, so survivors, families within the system. I was wondering if you could talk a little bit about the experiences that you've heard through those conversations.
Yes, I've come at this from a much more theoretical perspective, but as I was having a sabbatical in 2021, I was taking in as much as I could about domestic violence, parental alienation, and I identified a lawyer in Ottawa and contacted her and said, something really wrong is happening here. You know, when women are bringing up some of these issues about domestic violence, sometimes for the first time when they're in their custody dispute, judges are not believing that that's a realistic thing to bring up at that later stage. So looking at whether a counter argument of parental alienation is making that domestic violence go away. I read a lot of Suzanne Zakur talking about, does parental alienation make domestic violence disappear? And, you know, I absolutely agreed with that, which was not something that I anticipated hearing so much before I engaged in this research. And, you know, we're telling survivors, come forward, tell us your story. This is a safe place. We want to help you. But when when it comes to their custody hearings, we're taking away their children. And I think this is just a terrible thing that's going on. I'm mostly work within the criminal realm, but trying to look more in that family realm. And as Nia said, exactly, it's too siloed. So I created a course at Boralaska Faculty of Law to look at family violence as an entire course, to say, I don't care if you want to be a real estate lawyer or a family lawyer, I think you should look at what domestic violence is, what coercive control is, and you might be that last bastion that somebody has to talk to someone before something really terrible happens. So, you know, mostly I'm focusing on violence against women and women who are losing custody after they disclose that. So I focused, I've done 2 papers in the last 2 years, one on a survivor named SK and one on a survivor named TC, and looking at both of their cases and actually talking to them about what's happening to them. The message that I'm getting again and again is that they have no access to justice. They are begging people to take on their cases. They spend half their day phoning around trying to get a lawyer to help them with anything. And I see the result. They were unrepresented for a lot of their cases. And you have judges commenting on their, you know, unorganized materials that a self-represented person is submitting. I think that's a terrible thing, to try to criticize people who are trying to self-rep, who don't want to self-rep, who need that advocacy on their behalf. They simply cannot find that help. What the answer is to that, I'm still not sure, but I think we need to take on more of these cases as practitioners to help those most vulnerable amongst us. And, you know, there's so many intersexualities, as Mia is saying too. There's so much that's going on here with people who are immigrants to our country, people whose first language is not English, and really lacking in the ability to even get a legal aid certificate to help them with this. So those are the messages I see over and over again.
That's a real barrier to access to justice, right? When people can't, the system's supposed to be there to allow them to navigate it. You know, you have steps and forms, and people are supposed to help you to fill those out. But what ends up happening is you're standing in front of a judge, and you know you didn't do it the right way, and you don't get the result that you need. So to build a little bit of optimism into our perspective here, we do know that in Canada, in Ontario, that there have been a number of recent events or recent work that's happened So I'm just wondering if we can kind of examine some of those practices that are promising, that are going to support access to justice. And I'll turn it over to Laura Snowden to talk perhaps a little bit about some inquests and the commission work that you've done.
I'm happy to start the optimism train tonight. So yeah, I think it would be hard to have, or impossible, to have a conversation about recent developments in responding to intimate partner violence without talking about the Mass Casualty Commission, for one, and the CKW inquest. So I'll tell you a little bit about both, about some of the recommendations that have been coming through as we move into this momentum forward phase. And I'm going to start with the inquest because chronologically, the inquest recommendations came out first, and then the Mass Casualty Commission picked up on some of those recommendations and amplified them in its report. And so the inquest itself was called to examine the murders of Carol Culleton, Anastasia Kuzik, and Natalie Warmerdam, who were all murdered by a man with whom each of them had a past relationship. And the murders occurred in Renfrew County, which is why you may also hear the inquest called the Renfrew County Inquest or CKW inquest. And it was held in 2022. The jury made 86 recommendations for change. So we don't have time to go through all of them, but I'll give you a little overview of some. The first one was for the government of Ontario to declare intimate partner violence an epidemic. And you heard a bit about some of the advocacy that has picked up on that recommendation. Ontario itself has not adopted that recommendation. The jury in the CKW inquest also recommended that an intimate partner violence commission be established. And the aim of that commission would be generally to eradicate intimate partner violence, but it would also have more specific roles. For example, it could be a voice and an advocate for survivors and their families, could also advocate for more transparency around government responses to intimate partner violence. So that was another recommendation. There are also, obviously, there are a lot of others in the 86, but there are recommendations related to firearms monitoring in intimate partner violence cases, to records management systems, which all police would be able to access, which is that was a huge concern in the Mass Casualty Commission's work as well. Funding for intimate partner violence service providers, as well as specifically for intervention programs that would help people who are perpetrating harm against their partners. And also to enhance probation services monitoring of IPV offenders. So in terms of the Mass Casualty Commission, that one was not an inquest, it was a public inquiry, and it was a joint federal provincial public inquiry that was called to investigate the most lethal mass shooting in Canada. That occurred on April 18th and 19th, 2020 in Nova Scotia, and the perpetrator shot and killed 22 people, including one person who was carrying a child, who was pregnant. The commission had a very broad mandate. So I'm going to again focus on some of the recommendations, specifically some of the ones that are related to intimate partner violence. The final report came out in March 2023. And as I mentioned, the commission picked up that recommendation from the CKW inquest to declare, and they made it a bit broader. So the commission said that Canada should declare gender-based violence, intimate partner violence, and family violence as an epidemic, and give public health emergency level funding to combat that epidemic. The commission's report also included a number of other recommendations, so I'll run through a couple of them. For example, there are recommendations to have women-centric risk assessments, to create safe spaces to report violence, because we know that there is a very low reporting rate around gender-based violence generally, and so that is one of the suggestions to reduce some barriers. There is also a recommendation to end mandatory arrest and charging policies, which of course had some unintended consequences. And there are recommendations around education and social awareness programs to counter victim blaming and other myths and stereotypes, which we know can lead to inconsistent and ineffective police responses in intimate partner violence cases. And there's also a recommendation to shift to viewing community-based services. It's a bit of a perspective shift around community-based services to make sure that we're thinking about those services as equal partners to police agencies when it comes to combating intimate partner violence, and recognizing that those are not discretionary services and they need that sustained, consistent funding that is worthy of the epidemic of gender-based violence. So that's just a brief snapshot. They are all trauma-informed, carefully researched and considered. And so if you're interested in learning more about those recommendations, and you've heard a bit about how that can fuel change in this space, but you can find more online about both the CKW Inquest 86 recommendations and the Mass Casualty Commission's work as well.
Thank you so much. Yeah, it's really been interesting to read over the recommendations and the reports from the Commission, especially in the work that I've been doing with this project. So hopefully people can take some time to even just glance over the overviews of them, if that's possible. Deepa, I know that the work at the clinic, most recently, that there has been a connection to the National Action Plan that you mentioned, and how that's connected to a risk assessment that has been developed by the clinic. If you wouldn't mind speaking on that.
So one of the key components of the work that we do at the clinic is to advocate for a number of important access to justice and legal issues. And of course, the whole ethos behind all the work that we do is to support people build lives free from violence. So National Action Plan recommendations that the clinic, with the help of many service providing organization, lawyers, policy makers, the recommendations that are given in the National Action Plan, which is a roadmap for National Action Plan, was a project that was led by Women's Shelters Canada, funded by WAGE. And again, there are some, hundreds of recommendations, which some are exactly same, identical to the Mass Casualty Commission, as well as the inquest, and others are different. I was one of the people who was, many people who were invited to be a witness at the Casualty Commission. And I want to say something that I said at the time when I presented on the panel there. And I said that what we need to do is known to us all along. And that's what is really sad about some of the recommendations that we keep on repeating. So research studies, death review committees for decades have well acknowledged that in the cases where history of abuse is in a relationship, the risk for potential harm or lethality increases. One of the data that research studies that we quote is that for more than 2/3 of domestic homicide cases or femicide cases, there is a pending separation or it happens during separation. Lethality is at its peak when a woman or a survivor chooses to go to a justice system or court system of any kind. Knowing that, 4 years ago, the clinic started on a journey with the help of funding from Law Foundation of Ontario on a 2-year project to create a risk assessment tool with taking the account of complexities and the lived realities that have been discussed by my other friends here related to intersectionality, related to the people's lived reality, and understanding gender-based violence from that intersectional lens and from the lens of the community-based processes that people engage in when they go to the family courts. This risk assessment was designed for people who are working in the family court. So they could be working as lawyers, they could be working as family court support workers, they could be working as just paralegals or informants in the court. So the idea was that they could use this tool, which is designed as an intersectional tool, and asking questions and ascertain information about the risks that women might be facing, but also ascertain any additional risks women will face once they have connected with the system. That project and its success led us into a second phase of our journey, and which is a project funded by the Women and Gender Equality, WAGE, the federal government. And the full title for that tool is the Risk Identification and Safety Assessment Tool, RISA. And that's the tool which we are right now testing. It is a result of a 5-year national risk assessment project in collaboration with project partners from all over Canada. And again, while there are lots of risk assessment tools out there, one of the biggest piece that the clinic really struggled for years altogether is that most risk assessments do not take consideration of people's lived reality of their being coming from specific communities or without status, coming from racialized communities, coming from rural communities, coming from gender diverse backgrounds, so on and so forth. So that systemic oppression that communities face and survivors face coming from those communities is what we found was lacking. And the clinic with its own, from its own corner, with our own limited resources, is trying to fill the gap. And we are really excited about it. The team is right now testing the tool. So anyone who's interested in learning more about it, please check our website related to RISA, RISA. Thank you.
That's terrific. Being able to spread out the work of risk assessments so that it applies more broadly and connects people to what's actually happening for them, right? Or connects that information together. Neha, I was wondering if you might have some potential optimism from an area around that is not often known for being full of hope. Are there any positive developments or things that you could speak to that's going on in the criminal sphere right now?
Well, I'd love to say that Bill C-75 and what we're seeing with bail reform is heading in what in my opinion, is a positive direction. But I don't think that layering on more and more and more carceral approaches is going to fix the problems that we have with our justice system. Bill C-75, it added more layers into bail reform, especially with intimate partner violence. And we now have Bill C-48 before Parliament, and it's also addressing bail reform, trying to tighten the screws a little bit more with adding more more reverse onus bails, which means that the onus shifts to the accused person to have to show why they are releasable. That's what we mean by reverse onus bail. Our charter, our supreme law in Canada, tells us that everyone has the right not to be denied reasonable bail. So be very careful with that, because it doesn't say you have the right to bail. It says you have the right not to be denied reasonable bail. So given that caveat, the drafters of legislation can't just take away bail. They cannot just deny bail. But what they can do is they can shift onuses to the accused, or make it a little bit tougher to get bail in specific circumstances. Does incarcerating someone while they're waiting for their trial always help? In my personal opinion, no. People lose their jobs, they lose their livelihoods, they lose their homes. They often will lose subsidized housing, something they've been on waiting lists for up to a decade to try and obtain. They'll lose access to their kids, all while still enjoying the presumption of innocence, which is why bail is so important. We in Canada, we detain people who are innocent. We ask them to wait in jail for their trials, and before a decision is made about whether they're guilty or innocent. We see both survivors and perpetrators, and I don't like to use the word perpetrator, but it fits in this sentence. We see survivors and perpetrators waiting in custody for their trials. And that's a difficult thing for me to accept. So we see survivors of domestic abuse waiting for their trials, whether they've been wrongfully accused or they've been victims all their lives and have acted out in one instance. They wait in jail for their trials. We see people with significant trauma waiting in custody for their trials. What are we missing? While we're tightening the screws and we're adding more and more and more legislation, what we're missing is bail beds, housing for people who don't have plans, who need somewhere to go while they await their trial. We rely too much on surety releases, which is we want to release people to a responsible person. We don't have enough rehab beds. We don't have enough of anything. So the alternative to that, the lack of resources, in my opinion, should not just be jail. But that's where we're at. And as we add more and more legislation, we seem to be dispelling this myth that incarceration is the answer. What I do like about the Bill C-75 amendments and what we see reflected in the Bill C-48 proposal is more of an emphasis on people's community of origin. So I would ask you to all read section 493.2 of the Criminal Code, which compels our courts to take into consideration the communities of origin, so the indigeneity or the marginalized backgrounds that some of our clients come from, and really compels bail courts to look at the Indigenous status of our clients, and factored into that analysis is a fundamental understanding that our per capita rate of Indigenous persons in custody is deplorable. I have the benefit of sitting on the Akwesasne Court as counsel, and the Akwesasne Court is a self-governing court in on the Akwesasne Reserve. They have their own body of law that works with children and families. And what I get to be involved with there, and is my great privilege, is restorative justice initiatives with families as a part of self-governance. And so I get to, even though I'm the lawyer sitting there as prosecutor, I get to take a step back and let families talk through their issues, organize childcare, housing, protection orders, with the assistance of a community member who sits as I'm going to put this in air quotes, as the judge, but mostly as a community member who allows them to work through the issues on their own. And so that is a direction that I would like to see our communities go in. But we've got the Criminal Code and the Charter to contend with right now.
Sounds like there is a lot going on. And thank you so much for your reflections on that. Deplorable is a terrific way to capture the experiences for individuals who are trying to get support. Dr. Chapman, I was wondering if you could reflect a little bit on what needs to change in the court systems. What types of skills or knowledge is required in order to shift kind of the reality for individuals experiencing intimate partner violence?
Yes, thanks, Laura. I think it's education on a lot of these issues is so important. I was really heartened to see the Judges Act was changed to have mandatory training in some of these areas. I think that's a really positive step forward. But I had a friend in Ottawa, a lawyer, who said, well, how many times are experts actually used in family law cases? I'm like, that's a really good question. I want to go look at that. So I did some very cursory research, and the answer is not very often at all are experts actually used. Criminal trials, yes, that's what I'm more used to, but not seeing them actually testifying on what is parental alienation, what is coercive control, more information about domestic violence and trauma-informed perspective that some people may not feel comfortable disclosing very early on. So I was really, shocked to see how few cases actually had an expert. So this friend of mine in Ottawa had suggested, what if we got together a panel of experts? What if we identified who could possibly be an expert in some of these cases, that instead of reinventing the wheel every time we had one of these cases, that there could be this panel that was willing to write a report, willing to testify, knowing, so many of the ins and outs of this, because I'm a little concerned in some cases when I see judges saying, well, I don't need an expert because I know exactly what parental alienation is. Well, I've been studying it for years and took a year to, just delve into the topic. And I still think I don't fully understand everything there is about parental alienation. So for a judge to just, almost just recognize that they know what that is, I think is really misguided. And I think we need more education. We need more opportunities to talk to the judiciary about this and not just assume that they know, the smell test. Yeah, that kind of looks like parental alienation to me. I think that's really disadvantaging so many people. And again, educating young lawyers that I make them all in my class read Jennifer Kagan Viator's case about begging the court to allow her to have more custody of Kiera, that she wasn't safe with her father. And looking at that decision, the judge very much downplays a lot of the different elements that she had identified as red flags. And we all know that Kiera ended up dying with her father, murdering her in Southern Ontario. That we need to recognize even these situations where mothers are trying to be protective parents, of not pathologizing them, saying that they're crazy, that they're too much, that they're not organized, all of these things that you see again and again in a lot of these cases. We need to recognize a protective parent and listen to what they're actually saying about the situation, because they're the ones that have lived this, know this, and I think we need to listen to survivors.
That is definitely coming up in the literature over and over, is a survivor focused, and listening to the people who are being impacted by what's going on and how to best support them. As an individual who hasn't experienced that, I couldn't be the person to say that, and I think that comes across as well from the judges, to comment on something they don't understand. So thanks so much for going into that. So we're all here, all of these individuals here today on the panel, myself included. We do have a common shared place that we're coming from today, and that is the Improving Protection Orders project through the Law Commission of Ontario. So in addition to the momentum that we've just discussed, and the kind of hope on the horizon, I'm wondering if we could talk a little bit more about what's going on with the Law Commission project, and I'll turn it over to my lead counsel, Laura Snowden.
Thank you, Laura. So the Protection Orders project, the Improving Protection Orders project at the Law Commission of Ontario, is looking at why protection orders are not effectively preventing intimate partner violence. And our goal with the project is to come up with law reform recommendations to improve Ontario's protection order system. And I think it's important to say what I mean when I say protection orders. It's an umbrella term. So it includes things like family law restraining orders, but it also includes criminal protective options like peace bonds, bail conditions, sentences, probation orders, some of which could include no contact provisions or physical distancing requirements. Weapons prohibitions are also really important in protection orders. So there's a wide range of legal tools and remedies that can be considered protection orders. I think it's also important to say that every other province or territory outside of Ontario has civil protection orders that are available. And so as part of our project, we're considering whether that's something that Ontario should have in addition to our family and criminal, and there are child protection restraining orders under the CYFSA as well. So since the summer, we've had a series of informal conversations and consultations with a wide range of stakeholders in the protection order system. We've learned a lot, and we wanted to share a little bit of what we're hearing with you today. So I might say that the top line is that the system is not working very well. It's not working as it should. And we've heard a lot of variations on the theme of protection orders are not worth the piece of paper that they're written on. So we're hoping that we can use this project to go some way to make sure that they are worth that piece of paper and protective in nature. So that comes up in a few different ways, and I've just chosen some of them to give you a bit of an overview, and you've heard some of them coming out in the conversation already today, so I'll pick up a bit of that as well. But the first one that I've got is the system does not adequately take into consideration the needs and perspectives and lived realities of predominantly women and children who are seeking access to protection. So we're seeing a mismatch in terms of the conditions that are being granted in protection orders. For example, the protection order might cover the matrimonial home, but it doesn't cover the kid's school or the soccer game or whatever else may be part of that person's life, the protected party's life, that is a zone where they may require protection as well. We're also hearing a lot about communication breakdowns, and you heard a bit of that tonight in terms of the siloing of different court proceedings. It's really easy to imagine how one family could be caught in a number of different court proceedings. You could have a criminal case, you could have child protection proceedings, you could have a family court file happening. They could be happening at the same time, which means you're supposed to be in court at various different times. You may not have legal aid. It's expensive, it's time consuming. You may also get conflicting orders that are coming through. For example, if the bail conditions say no contact and the family court order says you must facilitate parenting time. So that kind of court coordination and information is really, really important, as is cross-sector information exchange, in addition to court to police information exchange, because enforcement is such a crucial part of ensuring the effectiveness of protection orders. And if we're not moving information about protection orders from the courts that are granting them to the police that are meant to enforce them, then the police have trouble finding their lawful authority to make sure that this breach is accurately dealt with, or that the protection order is actually a deterrent of any kind. So that's an important piece about communication as well. The other thing that we're hearing is about the use of the protection order system to continue abuse. So that's a concern that is coming up quite frequently, that we're very aware of and attuned to right now. So this is the idea that people who are perpetrating violence may be able to leverage the system to continue to exert control or coercive control specifically against the person that they may be harming. So we're in the process of drafting a consultation paper now that will be released in the fall. And we're also starting up some of our empirical data collection work. There's not a lot of statistics in Ontario around protection orders themselves in terms of conditions or timelines. So we're hoping to do a bit of court-based file research on that, as well as some more structured interviews or focus groups with survivors and possibly other stakeholders as well, to make sure that we're capturing views and perspectives on the protection order system itself of the people who are actually moving through and directly affected by that system. I think that's it from me. Thank you, Laura.
That's great. Yeah, thank you. You took what we've been doing in the last, 6 months and boiled it down into 5 minutes. Excellent. Dr. Chapman, I was wondering if I could bother you again. We have knowledge that the protection order system, as we've just heard, is not working well, especially for women with children. And I was wondering if you could expand a little bit more on the gaps that kind of come up with those parallels between family, criminal, child protection, the friendly parent kind of concept that I've been hearing quite a bit about.
Yes, and I was really glad again to see some of those changes to the Divorce Act to recognize family violence in different ways, recognize things like violence against pets and various ways. I actually went during my sabbatical. I went to Scotland for 3.5 months to see what they were doing. They've criminalized coercive control for years now, so I really wanted to see what they were doing, and I'm glad that the Divorce Act had these changes. But it's these concepts like the friendly parent that still remains in our legislation, saying that you have to be the parent that facilitates that relationship with the other parent. When there's coercive control, when there's domestic violence involved, this might be absolutely impossible for a person to do and to facilitate that relationship. And the inconsistencies, I think, are what really bother me in a lot of this work, that we're saying this exists, it's really important. We want to recognize that you have experienced domestic violence, that there might be child abuse of the child seeing that violence within the household. But when it comes to custody, why don't you just push down all those feelings that you have about that and just be the friendly parent who's going to facilitate that relationship? And I think it's that kind of inconsistency, that kind of dichotomy, that so many women just absolutely don't know how to navigate. And we've tried to find other ways to do this through custody hearings, etc. But I think we're not doing a great job. And although maximum contact is not necessarily a principle that we look at in Ontario and in Canada anymore, you see so many cases where custody, it's just, it's the most it's the easiest thing for a lot of judges to do, to just grant 50-50 custody, to not want to hear about domestic violence, to not want to hear about parental alienation. And it's almost like they're sweeping all those things aside and just like, let's split the kid down the middle, and that's the solution to the problem. And I think we need a much more nuanced position with this, and with the protection orders as well. Again, we have such, difficulties in trying to explain to people how to co-parent with somebody else when there's orders in place, what to do with that, what that looks like. And I think we're not giving enough guidance, especially to those who've been subjected to domestic violence. We're not giving them the guidance of how to actually navigate that process. And I think there's a way more that we can do through those means to actually do that in a better way.
That's great. Thank you. Thank you so much for that. Yeah, the dichotomy is especially striking when you talk to people that are dealing with this system and how it's not working for them. Neha, if I could ask you just about the kind of broader systemic components that comes along with attempting to improve protection orders and what can be done outside of perhaps the courtroom.
I think I just saw someone put in the chat about an integrated DV court, and then building on what Dr. Chapman said, how integrated, like how nuanced do we need to make it in order for it to meet every single need? And also, why does it need to be court? Why does it need to be carceral? Why does it need to be a justice system? Why are we not doing this within a therapeutic intervention? Why does it have to be one person wins and one person loses? One person goes to jail, one person walks away with, services. Why? I have all of these hanging questions. And what I've observed as a rural practitioner is essentially what I would call a two-tiered system. So where I work, we have no therapeutic courts. So we don't have a mental health court. We don't have a forensic psychiatrist where I work. We don't have an Indigenous persons court. We don't have drug treatment court. We sit on certain days of the month. So 2 Mondays of the month, let's say, we sit as a domestic violence court, but that is for pleas. And that is to ensure that the right person is there from the Victim Witness Assistance Program, and that we keep the parties separate from one another. But we don't have a nuanced domestic violence court. Do they have more of those things in urban centers? Yes. Do they have social workers sitting in court ready to take on clients or patients or whatever you want to call the population? Are they there and available? Yes. Where I work, the town I work in doesn't have a shelter. So we are seeing big gaps. If I wanted to send my client to drug rehabilitation, I would send them to Montreal, Toronto, or Ottawa, or somewhere up north if there was a specialized place. But I don't have access to any of that where I work. And we're a region of 200,000 people. If you go the entire Stormont, Dundas, Glengarry region of from Morrisburg all the way to Alexandria, but we just don't have access to those kinds of resources. I'm also seeing mandatory charging and Crown requests for no contact orders. The lack of discretion in policing and with prosecution is really hard. And when I was a young lawyer, I just thought that was just the way it was, and I couldn't push back. But the lack of discretion from a Crown or from a police officer doesn't mean that defense can't push back and say, well, that's not going to work in this situation. And so it's about educating young defense lawyers about when they should push back and when they can push back and say, well, that's not going to work. These parents need contact for the sake of the child. Let's set up contact at a supervised exchange facility, or let's set it up so they can use a Talking Parents app. But the broad lack of discretion is really hard to get around at times. And finally, I'm seeing exhaustion and confusion. For people who don't understand the justice system, it's a scary place. On my first day of law school, my professor told me that he reminded me that people who are involved in the justice system think about their cases every single day, all day long. They don't let it go. They think about it constantly. And as a lawyer carrying, hundreds of cases, I'm not thinking about my client's case, my specific client's case constantly. I think about it when it comes up, when it's, around the corner on my calendar. My client is exhausted. They're confused. They're thinking about their children. They're thinking about if they can make rent without a child support payment. They're thinking about their confusion about their bail order and how it doesn't match their family court order. And they're thinking about their safety. And so we forget that sometimes as lawyers. And if I could have just one client, if I could financially afford that, to just have one client and take them all the way through and solve all of their nuanced problems, that would be a dream come true. But that's not how we practice law.
No, it is not. Not at this juncture anyways. So we're making good time, but we only have about 10 minutes left. And Deepa, I was wondering if you could kind of touch a bit on the changes or what you're hoping to see as a result of the Protection Orders project. And then if we have time for a couple of questions, maybe from the participants. So,
this whole question about what do I really want from the project, I think the one thing that I would really want that once the report is out and once the recommendations are out there laid out, that those are followed and they don't just sit, like as we talked about earlier. There are so many recommendations out there to solve this problem of gender-based violence, and we know in many situations what needs to happen. In terms of the protection orders in particular, I have to say that in theory, it's the improvement of the system that we really need. We don't need, we don't want that we should start all over again and rethink the whole system. I think improving the system is definitely what is needed, because the intention behind the structure is really right, correct. But it doesn't work. And it doesn't work because I think we talked about, how we are so happy that there are these specialized trainings now being expected of judges, but we don't need it only for judges. We need effective training for judges. So that's like the most important thing. But law enforcement, court staff, we need everyone to be able to better understand the dynamics of the domestic violence, and especially when this family and one of the family members is seeking a protection order against someone else. And doesn't matter, of the nomenclature, in what circumstances, whether it's bail conditions or peace bond or protection order or civil remedy as is being proposed. There is intersecting inequalities. There are myths and stereotypes about the survivors that are existing in our system. Our legal actors and our enforcement actors do not work with each other. They literally, sometimes when I go to those policy recommendation meetings, I just say, I want all of you to be friends and be listening to each other and collaborate. And I think that can really change the experience. Technology integration, I think that's really huge. We are so far behind in thinking about and exploring the technology to make protection orders more accessible, whether it is text messaging alerts, whether it's online tracking, whether it is electronic filing system. COVID really helped in moving things along in some ways, but in some ways we are still so behind. I don't know how many of you know, but during COVID, one of the things that was not available was peace bonds. They kind of were put on a pause, and none of us, because we were all surviving a pandemic, had enough bandwidth to say, like, how come a very important tool has not been brought into the technology integration. Support services for everyone who's part of that unit, right? So I know that there is this whole concept of support for survivors, but I don't believe it's only survivors who need support. I think everyone involved in that situation needs support, and they need a system of accountability which can help them protect themselves, protect people involved, and prevent ongoing violence that happens. And most importantly, I think, we talk about accountability of a lot of systems, but then we create systems and then we forget to actually review them and update them. So mandatory charging, Neha just talked about it. There was a reason why mandatory charging happened, because prior to that, the system was completely misogynistic about these cases of domestic violence, right? So feminist legal scholars came forward and asked for it for a reason. Now, it has been many years that it came into existence. We don't have a system to review. We don't have a system. We have all these anecdotal information that we can share when we sit in circle like this and say, a lot of gender diverse people also get charged. A lot of women get charged. But where is the data for that? And then it is actually asked of us, can you provide us the data? And I'm like, with my budget, I don't know how much research I put behind a national study on that. But yes, we do need a proper tracking of what's happening. And I'm really happy to be part of the project. I'm really happy that the project is proceeding. And I really, really feel like the policymakers, I hope, and lawmakers, more importantly, actually see your recommendations and follow it.
Yeah, so much of what I'm hearing you say, Deepa, is about that very holistic wraparound approach where you're looking at all of the parts, all of the players, and giving teeth to some of the recommendations. We've had many, many recommendations coming out, and they, as we heard, are being essentially repeated in other inquiries and inquests. So we only have, I'm going to say 3.5 minutes for questions from the audience. And when I take a look over some of them, there are some common themes. So I'm wondering, and this is potentially my bias as well, I come from a mental health background, but talking about the psychological or mental abuse, how trauma can inform the work that's being done in intimate partner violence. And I'm just going to open it up to all 4 of you. You can fight it out of who wants to answer.
I know that I was the one talking, but I'll very quickly say something. I really like the term trauma-informed. The clinic really takes pride in doing trauma-informed work. But the trauma-informed education and trauma-informed grounding of legal practice needs to go hand in hand with anti-discrimination, anti-bias, and intersectional practice. If you are just going to do one, then you might actually just switch the same challenges and you perpetrate same challenges that communities are experiencing in your practice because you're not really grounded in their lived reality. And I feel if people are interested in trauma-informed practice or they want the system to be trauma-informed, it's really important to be really reflective on those lived experiences. And for our judges, I feel like that's where they need to start, and that's where the system needs to start. The mental health and domestic violence have a very direct connection from the side of the perpetration, but also for the survivorship. People experience a very deep trauma, life-altering trauma with the experience of violence and coercive control, and that changes their life. And the healing takes a very long time. And we as conduit of the system, as lawyers, are part of a journey at a very specific time, but there is a journey before and there's a journey after.
Can I jump in on more trauma? Is that okay? Thanks, Laura. And I saw a couple comments about this, and one of them was asking for more information on it, and I would direct that person to the Mass Casualty Commission's violence report, because there are a lot of definitions in there which would give you more information on the psychological and emotional harms that are involved in intimate partner violence. And then the other one that I saw was about the potential, our survivors of intimate partner violence being screened for potential brain injury, And I think that's a really important question about trauma as well. In the Protection Orders Project, evidence is a key part of what we're looking at, how evidence is moving through the court system or coming in front of the decision maker on a protection order application and being analyzed by that decision maker. And if you need to convince, as a survivor, if you need to convince the judge that you have a reasonable fear of future violence, you may present that information differently if you have a traumatic brain injury, whether that came from the violence that you experienced or is otherwise part of your lived reality that you're bringing with you to the court. And so we're really interested in thinking carefully about how to make sure that complete and comprehensive evidence, and you can apply that, you can extrapolate it out, right? If you have another type of disability, the way that you present might look a little bit different. If you are traumatized, the way that you present might look a little different. It might not be a linear narrative. And so that's something that we're thinking carefully about in terms of evidence in protection order applications and what that looks like, and how we can address the barriers that are created by a system that isn't necessarily designed to consider that someone may have a traumatic brain injury when they appear in front of the court. So I thought those were great questions.
Yeah, I really like the reflection on it, and thinking about how to be compassionate to that individual themselves and their, as Deepa was saying, the lived experiences of these individuals. You know, I don't know what it's like to live in someone else's shoes, but I can support them to the best of my ability by listening to them. And that's what I'm also seeing coming up in the comments there. We are completely out of time. So I do apologize, because I have many more questions that we could answer, I'm certain. But I did want to let people know that this session is being recorded and it will be posted online if people want to tune in. Of course, you can always go online to get more information from the LCO. So lco-cdo.org to get more information about the Improving Protection Orders project. And thank you so much to the panelists today, to Laura Snowden and Dr. Francis Chapman and Neha Chugh and Deepa Mattu. Very grateful for your time today, this evening, and for participating, and for everyone for being here. Thank you so much.
Thank you.
Thank you for moderating us, Laura. Thanks everyone for attending.